Deonarine and others against Ramcharan.
Good morning, my lords.
Mr. Jairam, good morning.
My name is Sinath Jairam.
Mr. Soinath, good morning.
Morning, madam.
It may assist if I say at this stage that the board has, of course, considered the papers in detail, and that it does seem to us that the issue of the validity of the agreement is going to have to be decided at some point in these proceedings.
Yes.
And in that context, therefore, the board would be assisted if in your submissions you could address the questions. First, whether the Court of Appeal was wrong to uphold the judge's refusal to decide the issue. And secondly, if the Court of Appeal was wrong, how should the matter now best be resolved?
We are much obliged.
Thank you very much. Mr. Charan.
We are grateful, my lords. I take it that your lordships have the appearances on both sides.
Yes.
Grateful.
We do.
Well, my lord, in that context, we had proposed to address the board on two issues. Precisely what your lordship has identified, whether the High Court, and feeling that the Court of Appeal ought to have decided and granted a declaration as to the legal validity and enforceability of the compromise documents. And the second issue, my lords, whether the High Court was entitled to decide the issue of whether 50% of what is referred to as the Laurel Valley lands was held by the deceased on trust for the appellant. I just want to make it tolerably clear that the second issue in our respectful submission is in the alternative only, and would only arise if the compromise documents are not valid. We don't want to appear to be greedy. But it must be argued in the appeal, just in the event. We don't know how the lordship will decide, but we are grateful to my Lord Jones. My lords, I am somewhat, due to the fact that I prepared the compromise documents, my learned friend Mr. Rowan Pennington Benton will address your lordships on the issues after I've outlined the facts. The facts are the documents are somewhat confusing, and I need to put them in some kind of sequence. If I may do that with your leave. My lord, I think the bench memo has captured the essential point. Siram Sijatan, also known as Peter, died testate in Trinidad, in the country of Trinidad and Tobago, on the 21st of March, 2008. Essentially, in his will, after the usual clause about payment of just testamentary debts and expenses, etc., he devised all his properties among his 4 children only. The percentage doesn't matter in our view because he gave them all. He excluded the appellant. And in that will, he appointed the first name respondent as executor. Will your lordship require reference in the bundle, the electronic bundle?
No, we're grateful, but we are familiar with the background facts.
Thank you. My lords, before an application was made for probate, Lauralee's attorney was in correspondence with my learned friend, Mr. Nibar, who sits at the end. And those correspondence the lordship would have seen. Anyway, there was no undertaking nor any agreement, as a consequence of which the appellant entered caveat, and that caveat was renewed from time to time until it was warned. And after the warning of the caveat, an appearance was entered. My lords, the appearance is at EB, if I may refer, the short EB, electronic bundle 0154 to 0156.
Thank you.
At that stage, my lords, it is obvious that the proceedings became contentious probate proceedings under the Wills and Probate Act, and in particular, Section 70 thereof.
Now, where do we find that in the bundle, Section 70? I don't think it's in the authorities.
It was sent to the registry on Friday.
It was sent separately, right? Thank you. We won't take time now.
And the CPR also deals with that, my lords, at Part 72, 72.1 in particular. At that stage, therefore, in our respectful submission, the onus shifted to the applicant for the grant of probate to commence contentious probate proceedings. However, we point out respectfully that no proceedings were commenced by the first respondent or any proceedings, nor any application was taken out to strike out the appearance. The caveat. Much obliged to my learned friend. Now, my lords, there are no rules either in the Wills and Probate Act nor in the CPR as to any time frame within which you may do so. And just for completeness, we have looked at Section 23 of the Interpretation Act. That's Chapter 301. And that says, where no time is stipulated in any law, the act must be done without unreasonable delay. Now, you will see, my lords, when the proceedings were in fact commenced on April...
I'm sorry, what commenced?
When these proceedings were commenced,
yes.
These proceedings, they were not contentious probate proceedings because time was moving as far as our case is that the children, the beneficiaries named under the will, and the applicant, the appellant, they were having discussions and resulted in an agreement. I will come to that in a moment. We respectfully point out, my lords, that the children and the appellant were in discussions, and those discussions happily are evidenced by a series of documents. And if I may just tarry you, for the sake of complete...
I thought, that when the proceedings were commenced, it was part of your client's claim that probate shouldn't be granted to the will, or alternatively that a different executor should be appointed.
That's correct, my lord.
And aren't those contentious probate proceedings?
My lord, yes and no. Because we are saying it was, from a practical point of view, it is pointless to have two legal personal representatives. The children and the appellant had agreed that she be appointed in the United States of America as the LPR, but they did not agree that she be appointed as the LPR, if I may use that, in Trinidad. And we were saying it is pointless to have two executors, more expenses and so on. And since no probate proceedings were commenced in the conventional sense by Dr. Deonarine, we were essentially seeking declaratory reliefs as to the enforceability of the compromise documents.
The probate proceedings, up to the point of the entry of the caveat, had been administrative proceedings.
Yes.
Were they not converted into contentious probate proceedings at the point that the caveat was entered?
At the point of the appearance, yes.
So why was it necessary to start new probate proceedings?
There was no new, any probate proceedings, my lord, as far as we are concerned. Our action was not a probate action, nor a contentious probate action.
I understood you a moment ago to say that once the caveat was entered and it became contentious probate proceedings, the onus shifted to the applicant for probate to commence contentious probate proceedings.
Yes, but more than 1 year, 9 months, I believe, had elapsed, and no proceedings were commenced by them.
My question is, why wasn't the non-contentious procedure automatically converted into probate proceedings, into contentious probate proceedings?
My Lord, we are saying there is no need for that in any event, my Lords.
Mr. General, as I understand it, all that had happened was that a caveat had been lodged. The executor in the will warned the caveat, and an appearance was entered to the warning.
Yes,
But that's all that had happened up until then.
that's correct.
So I think you said, well, once that's happened, there have to be contentious probate proceedings, and I understand that submission. But there weren't any proceedings, were there? There was just the caveat, the warning, and the appearance to the warning.
And everything went silent.
Yes.
Yes. So time was passing, my Lord.
As I understand it, you simply submit that if in those situations the executor wants to prove the will, he can't do it in common form. He's got to go to court with contentious probate proceedings.
Yes.
And get his probate bell, book and candle, as one might say.
Yes, my Lord. And may I, on that point, all those reliefs, those points raised by my Lord Stevens, if I have it correct, we no longer seek the removal of Dr. Deonarine. We no longer seek that the appellant be appointed the LPR in Trinidad. And my Lords, happily, and we will come to that, we have agreed at the Court of Appeal when we applied for leave to come before your Lordships that the application for probate be proceeded with.
I was going to ask, what's happened? Has probate now been granted?
Well, my Lord, there's an order of the Court of Appeal, but that's an administrative aspect. I think those instructing us wrote to the registrar asking, and I don't know what has happened. But as far as we are concerned, we have done everything that we could have to facilitate that, because the Court of Appeal ordered that the caveats be lifted. So there's no legal impediment in the way.
Yeah, my question was simply whether probate has now been granted.
And the registrar has an order. We made sure we sent an order and said, this is the order. Please do what is necessary. So, my Lord, we are saying, in that context, if I may, if on the basis of Crowden and Aldridge, if your Lordships accept, as the courts below have accepted, the viability of that decision or the reasonableness of that decision given by Mr. Justice Jonathan Sumption, as he then was, QC, they both seem to have said that the issue about the enforceability of the agreement must await the grant of probate, so that is no longer a live issue for your Lordships. We could pursue and continue on the basis that probate has been granted. And if Crowden and Aldridge is correct, and we submit it is correct, my Lord, it has followed once in Hong Kong. We haven't found any other...
Can I just ask, just go behind that for a moment? You say that the issue of agreement, that the court said the issue of agreement must await probate. You say probate has now been granted. But I can see Mr. Pennington Bentham shaking his head and suggesting that probate has not in fact been granted.
Well, it is out of our hands, the parties' hands. It's an administrative matter.
I understand that submission, but
yes.
Is anyone able to assist the court as to whether probate has been granted or not?
Ms. Jairam says it hasn't been granted as yet, but there's no impediment. We no longer, the caveats have been lifted according to the order of the Court of Appeal. No. Okay, here's the order. Yeah.
It might be clear, probate in your submission has not been granted, but it's also your submission that there's no reason now why it should not be granted.
Precisely.
In common form, i.e. without any further proceedings.
Sorry, my Lord?
In common form, without the caveat's gone.
Yes.
So there's nothing to stop probate.
Nothing to stop it.
Administratively.
Precisely.
But you don't know why it hasn't been.
No. The registrar, in response to Ms. Jairam, said they have it, they are aware of the order. My Lord, just for your note, electronic bottle 1419 is the order of the Court of Appeal. And if I may just it is hereby ordered that a stay of execution of the order of the Court of Appeal made on the 4th of September 2020, that is when the appeal was disposed of, be and is hereby granted pending the determination of the appeal before the Judicial Committee of the Privy Council, provided that A, the caveats filed by the appellant be lifted to enable the executor in the last will and testament of C.Ram C.Jatan, Dr. Ramraj Deonarine, to proceed with his application for probate of the said will, etc. Dr. Deonarine shall not distribute nor diminish any of the assets of the estate, including monies collected, save for paying the taxes and rates and so on, so that the properties would not be sold by any public authority. So that no distribution, and we say, with respect, rightly so, ought to take place. My Lord, I was pointing out, because of the allegations made regarding the validity of the compromise documents, that there were a number of documents. If you look, if I may, it was EB 0694. The children were writing to my learned friend Mr. Nibar, February 23, 2010. My Lord, and you see they signed before Notary Public. They said they have come to an amicable agreement. The next document, my Lord.
Just before you dive into these documents, so far as there's an issue as to the enforceability of these agreements in the form which you contend for in these proceedings,
Yes.
Is there any reason why that should not be resolved in the probate proceedings before the judge who in fact heard the proceedings, that judge now being in the Court of Appeal?
No, my Lord, they are not probate proceedings. When you look at the definition of what is contentious probate, because these is a declaration really we are seeking, that the compromise documents are enforceable.
But you'll come to that then as to...
Yes. My learned friend, Mr. Owen Pennington Benton, will deploy the arguments. I'm reluctant to argue the case fully before your Lordships because I had prepared the compromise documents on the power of attorney. But we'll come to that. The next document I will give your Lordship the note, is a letter dated 27th of September 2011, and they were writing to dear Mr. Jairam.
Sorry for interrupting, but I appreciate that it wasn't your obligation, as it were, to prove this will, and you didn't commence the contentious probate proceedings in order to prove this will. But certainly you commenced proceedings that wished the will to be altered. You commenced proceedings to have an executor, a different executor appointed. Now, why is that not contentious probate proceedings?
My Lord, I'm grateful, my Lord. When you commence proceedings, the judge doesn't have to grant everything that you ask for. And we have relied, for example, on Section 20 of the Supreme Court of Judicature Act, that the court may give all such remedies or relief as appear to fit the case. Now, we say, my Lord, our position is that they were not contentious probate proceedings because we are not querying the will.
You know what, sorry?
We were not querying or questioning the will. We did not challenge the validity of the will.
I see.
And it was a discretionary relief. It could have been granted in any normal civil proceedings.
I'm a little puzzled as to why it matters whether they're contentious probate proceedings. Yeah. I can see there's a very important distinction between contentious and non-contentious probate proceedings because the latter don't go anywhere near a court. But contentious probate proceedings, presumably, unless there's some other direction, come before a High Court judge in Trinidad. I don't know whether there's a group of Chancery judges who deal with them, or to any High Court judge in Trinidad, and they come and are dealt with as High Court proceedings. And why does it matter whether they're contentious probate proceedings for present purposes?
In all respect for you, it doesn't matter.
You say it doesn't matter?
It doesn't matter. Because you see, contentious probate, my lord, the CPR, you have to do affidavit of testamentary scripts and a number
Yes.
of things.
Yeah.
We were not going there. The judge could have, in the proceedings that we have commenced, exercise her discretion and say, well, Mr. Jairam or Madam Appellant, claimant, I'm not granting you this relief.
So there's nothing to stop the judge going ahead and deciding the validity of the compromise agreements in your submission.
Precisely, my lord. That was the issue before the court.
And all this contentious, non-contentious is a red herring.
Completely.
Yeah. Thank you.
Completely. And the respondents pleaded fully as they did. And there are only two issues they raised on these. I noticed that they have departed from their case before your lordships. They have raised that the documents, they admitted they signed, but the documents presented to the court are not the documents that they signed. And secondly, they said they did not have independent legal advice. Well, that was for them to prove. They never came up anywhere near to it. Anywhere near to it. And my lords, while I have your ears, I know it's not the practice of your lordship's board to decide these issues, but this is a case where there are no conflicts on the evidence. And to send it back would be a colossal waste of judicial time and resources and costs. These parties have been in court for a long time, my lord. And the courts below sidestepped their duty and obligation in deciding the issue. They should have decided whether the compromise documents were valid or not. They haven't. I am not aware, I don't know, I say this because I've been at the bar a little long in Trinidad and Tobago. I've never seen a case in Trinidad and Tobago where anyone says the bequests or the gifts under a will must be changed, like the Alden and Crowden, the Crowden and Aldrich case. And maybe that is why they were hesitant. I don't know. But we'll have to find a judicial reason for it. There was simply no good reason for not deciding. The judge at first instance, and their lordships in the Court of Appeal said, you know, they referred to your lordship's case of Chin and Chin. That was the case from Jamaica that came to the Privy Council. And they said, normally they will send it back. Well, as a matter of completeness, and for the record, I should state, by that time, the learned judge had been promoted to the Court of Appeal. But we have had precedents in Trinidad, where judges are retired and they didn't finish their judgments, hue and cry by the public or litigants, and they had to bring them back, swear them, and finish the judgment.
But there's nothing to stop a Court of Appeal judge as they're sitting as a High Court judge.
No.
No.
They were entitled
to
to.
be sworn or anything like that.
Yes.
They wouldn't have to get the, as in Jamaica, as a retired judge might have to do in Jamaica, get a Governor General's permit.
Precisely.
In this case, they can just sit one day in the High Court.
My lords.
I'm asking,
Yes.
in this jurisdiction, if, for example, there's not enough work in the Court of Appeal, there's nothing to stop a Court of Appeal judge going and helping out clear a logjam in the High Court.
Yes.
My question is whether that can happen or does happen in Trinidad.
It has happened. Your lordships, maybe, I'm not sure, the current panel have sent back cases to the Court of Appeal where they heard evidence, at least fresh evidence, and deciding an issue or issues. And they can. But they express a reluctance that I do not fathom. The point is...
I think that's a rather different point, Mr. Jairam. The question my Lord was asking, I think, was whether there's anything to prevent a Justice of Appeal in Trinidad and Tobago from sitting in first instance.
I am not aware of any provision preventing their lordships.
Thank you.
And do you go further and say that it does occur or not?
It does.
Okay.
My lords,
Can I just be clear about what you're saying about Crowden and Aldrich?
Yes.
Because I'm just a little bit puzzled. It may be that you're going to come on to this, and I wouldn't want to take you out of turn, but I'm just a bit puzzled about why this is in any sense regarded as controversial, in the sense that it's surely standardly accepted that one can have a deed of variation of a will.
But I don't think it has been controverted by my learned friends. Now, the courts below, they have accepted All they say, but the enforceability of your compromise documents must await the probate of the will. They did not.
Is that what you're saying this case stands as a proposition for?
Yes, I said all the beneficiaries can unanimously agree to vary the bequest of a will.
Yeah.
And it stands to reason, my lords, quite apart from authority. If all of us got the estate of our father, we could say, well, it's okay, we'll divide it however we unanimously agree.
But that surely can't possibly be controverted.
No, it is not.
I mean, it's happening every day of the week.
Precisely, my lord. Yes, yes.
Variation.
Yes.
So why do you need... Cronin and Aldridge was a particular application. It wasn't setting out the principle that one can have a deed of variation of a will, because that's so axiomatically obvious.
Yes.
You wouldn't need any, almost, I mean, no doubt there is some old authority that would actually say that, but surely it was the application where one had an agreement, but without a deed, and the question was whether the agreement, rather than the subsequent deed,
yes,
was sufficient. But that one can vary by at least a deed, and one would assume agreements. Surely can't be controverted.
It is not, my lord. It can't be. And it was accepted by all. It looks as though form has trumped substantive justice.
We'll
Sending us all
hear your opponents in due course. But as I understand your submission to be, the point that's been taken against you thus far, and indeed successfully in the Court of Appeal, is not that you can't vary a will by a deed entered into by all the beneficiaries, but you can't do it before probate, and you can't resolve any dispute about whether you have done it before probate has been granted. It's a sort of timing issue that they're taking.
Yes.
I think their case, as I understand it, is that it's premature for the court to resolve any question about the validity of the deed of variation until there has been probate.
Yes, well, my lord, I'm grateful. Well, we could proceed on the basis that probate has been granted, because although not actually granted, there is no impediment in law in the way of the registrar issuing a sheet of paper and said, grant of probate, etc., etc.
But your primary submission, as I understand it, is that it doesn't matter whether probate's been granted or not. It's entirely appropriate for a court to grant a declaration dealing with an issue between the parties
as to
whether or not a memorandum of that kind was ever properly entered into.
Yes, because once probate is granted, there's nothing to preclude the executor from distributing. In fact, he has to obey the division of the property or the distribution of the property in the will. There's no other document or no other order could prevent him, because under the Wills and Probate Act in Trinidad and Tobago, the Administration of Estates Act, he has his duty to perform. So that is why we took the precaution of piling caveats and entered an appearance.
But it's implicit in the Court of Appeal's order to which you referred us that the Court of Appeal recognised that in due course the compromise agreement might be found to be enforceable, and that's why they restrained the Dr. Deonarine from making any distributions in the meantime.
Well, my lords, what has happened in this case, the learned judge unusually gave directions that the respondents file submissions first. And there was some sort of argument between bench and bar, and the lady that we are the claimants. And said, no, I want to hear from them first. And my learned friends, I mean no disrespect, they threw everything at us. Some lawyers say the kitchen sink. And therefore, we went down, I went down a rabbit hole, because I thought we have to answer all the issues they raised. And my learned friends were saying that, look, these were contentious probate proceedings. In the Court of Appeal, I had to make it tolerably clear to their lordships that these are not contentious probate proceedings. And in fact, my lords, you will see the intertwinement of the claim. That's another thing latched on to my learned friends.
Forgive me for taking you out of your course. I think you submitted a moment ago, but it really doesn't matter whether they are or aren't contentious probate proceedings, providing that there's an issue before a High Court judge for determination.
Yes.
Yeah.
Thank you.
Do we need to go further into the controversy about whether they are or not?
My lords, would you like me to point out the documents that the children and Lauralee were engaging on this, and it's on the record. Very quickly, if I may. The second document showing that they were negotiating, dated 27th of July 2011, that's EB 0695 to 60696. Again, they signed in the presence of a notary public. I ask you to note, my lords, that the brother Terence Citation had a power of attorney from his sister Laura, and that's at EB 291, but that was not registerable in Trinidad and Tobago because of the form it was in. And he was at all times signing on behalf of his sister Laura. The appellant's name is Lauralee. At 291, you will see the one-page document. And my lords, whilst I have your ear on that, and maybe in the electronic bundle, EB 1654, that's the Registration of Deeds Act, and that section 10, subsection 1B at page 1661 deals that where a deed is executed outside Trinidad and Tobago, as in the case of the deed in this case forming part of the compromise documents. And you will see, my lords, at EB 1666, section 20, deals with a power of attorney. And that is why the power of attorney was redrafted by me and registered. I will come to it in a moment. The next document, my lord, is at EB 0697, dated September 6, where the children were writing to me again, and that is followed by another letter of September 6, EB 0698. Again, they were writing to me. They were asking for my advice on the matter. The other letter in the series there, it's another letter at EB 0699, dated again 6th of September. And this is a little more expansive. The pages at bottom, internal reference, page 1 of 3, page 2 of 3, and then page 3. And again, they signed in the presence of a notary public. And you will see, my lords, that they were dealing with the properties in the U.S. there, those properties alone, and they agreed to give Lauralee, the appellant, the house in which she was living. That is the house in Davie. My lords, I wouldn't trouble you with the petition and the like. My lords, one of the defenses raised by the children was that, and I ask you to note, they were all adults. It's in the transcript. If you want, I can give you the reference. There were, I omitted to say, because I assume, there were two witnesses who testified for the appellant, namely the appellant herself and Horace Ramcharan. For the defendants or the respondents, Dr. Ramraj Deonarine, Gina Citation, and Terence Citation. The other daughter, Lisa, gave a witness statement, but she was never called as a witness. And you will see, my lords, at EB 1033 to 1035, the law firm of Jacoby and Jacoby was advising Gina and Lisa. And their correspondence, or letters, I should say, between Mr. David Farbstein and Jacoby and Jacoby. And you will see, my lord, at EB 0401, Gina read what Mr. Farbstein, who was Lauralee's attorney, wrote and said there were a couple of misspellings. And there were further emails, and then Gina also said EB 400 that Terrence's name was misspelled, and when it's corrected, they would sign. Now, my lords, crucially, there was a power of attorney given by Laura in favor of our brother, and that starts at EB 0159. And you know, my lords, when you look at, now, no point was taken in the pleadings about this power of attorney. It was not challenged. And I ask you to note the person who prepared, the Sina Jairam SC, and this power of attorney is dated at EB 0170, 25th of January 2012. The very first clause of the power of attorney at EB 0161 says she's authorizing her brother Terrence to compromise with Lauralee Ramcharan. This was to enable him at law to bind her. And to add icing to the cake, at clause 27, at EB 0169, she says, for the avoidance of doubt, all of the above powers, authority, and discretions are for and on and/or this power of attorney is for the limited purpose only of dealing, finalizing, agreeing, compromising, executing deeds, memoranda of transfers, agreements, of and touching my inheritance, shares, rights, entitlement, and interest coming to me through the estate of this, and/or arranging, settling, and compromising with Lauralee Ramcharan.
So who drafted this power of attorney?
I drafted it, my lord. And they never attacked it in pleadings. In fact, Dr. Deonarine, at paragraph 15 of his defense, and that's at EB 0269, he admitted the power of attorney, whilst the two daughters, Jean and Lisa, and that's a lawyer's plea, my lords, your lordships are aware, they said they made no admission of it. Terrence didn't say anything about it. But he did admit in cross-examination that he was authorized by his sister. So, my lords, the next document, the 27th of January 2012, the agreement, EB 0175, it starts.
Sorry, could you give that number again?
Sure, my lord. EB 0175.
175.
That's the agreement. Very extensive agreement dealing with legal advice, and they were advised. Now, these documents were sent to them abroad, my lord. And in the cross-examination of Gina, she admitted that Lauralee gave them these documents in an envelope, and she took it to her brother's store, Terrence, where they signed it. The point is, they had sufficient opportunity to take copies, they had sufficient opportunity to read, to take advice, and what have you. And it's really egregious for them to say that they didn't know what they were signing. And sort of inferentially saying that Lauralee and her attorneys, my lord is there to your lordships to read. I just want to point out, my lords, that insofar as the Laura Valley property is concerned, it is not captured in the operative part of the agreement. It is referred to in recitals 6 and 11 of the agreement, and 6 is at EB 0178, and 11...
Sorry, the reference again? Sorry.
0178.
Thank you.
And clause 11 is at 0179. And the operative part of the agreement, my lords, you will see specific properties of that agreement. And clause 4, according to the compromise arrangement arrived at by them, clause 4 of the operative part is at 0186, which will fall under, if I may borrow the expression, the residuary estate. It will fall there, and they each receive 20%. All other assets of the estate of the deceased, except those dealt with in paragraph 3 above and paragraph 5 in this agreement, wherever situated, shall be divided equally as between the children, common law wife, etc. And my lords, I ask you to note the page with the attestation and execution clauses, starting at page EB0198. That page is not a standalone page, but a continuation of the agreement. And the question
Sorry, the page number again, sorry.
0193. And I asked them when they signed these agreements, didn't they see that the pages were numbered consecutively, and so too the clauses? And they said yes. And if you were signing just the signature page, didn't you ask Lauralee where are the other pages? And you will see, my lord, the answer they gave that no, they didn't ask. I asked them, whose fault is it? But it gets worse, because she admitted in the cross-examination that she was given in an envelope. She took it to the bursar's office, where they all three of them signed. So she says.
Are you going to take us to those, or are we?
Yes, my lord. I will take it. I will give you the references. So I ask you to note this, and that annexed, my lords, a number of documents, including the appearance of the warning. That was followed by a deed of arrangement of the same name. And my lord, since I did it, I am entitled to tell your lordship, to avoid all arguments about consideration or past consideration, this was done by deed. And that starts, my lords, at EB 0206. And essentially, it has the same provisions as the compromise document. And the pages and the clauses are numbered consecutively as well, or chronologically. Now, my lords, the strangest thing, when the learned defense pleaded to this, they have only raised two defenses. They said the document produced by Lauralee, the documents are not the documents they signed, and secondly, they had no independent advice. I notice in their speaking note, I'll come to in a minute, they're taking other points about the notary public and all manner of things. It's trial by ambush. They can't come here with hindsight and say all these things. I'd asked Gina, and Terence in particular, have you? He admitted he knows the criminal law, he had brushes with the criminal law. I said, if you're saying you don't know the witness to these documents, did you report it to the authorities, the police or the feds, as they say in the USA, or the police in Trinidad? No. Didn't report it. I said, but if the court pronounced in favor of these, it means that Lauralee is getting something that is contrary to law. It's a fraud. And Krishna D. Hari, my lords, oh, by the way, my learned friends made, to have an agreement registered under the Deeds Registration Act, one does not need to have an affidavit of due execution. It's only a deed, and that's in the Registration of Deeds Act. If it is registered abroad, you just need one witness who must depose before a legal functionary or a notary public. If it's executed in Trinidad and Tobago, it must be executed in the presence of at least one witness and a legal functionary. And they are all set out who may be a legal functionary, a lawyer, the Registrar General, Judge of the Supreme Court, etc. So we say all requirements of law were complied with to have these documents registered, and the registry would have returned them. But it gets more interesting, my lord. When Ms. Jai, the signature, and this is what the judge alluded to when she says the statutory declaration is given its contemporaneous nature, which show that the agreements are valid. And my lords, many months after, when it was discovered that the deed did not have the documents annexed thereto as the compromise agreement, a deed of rectification was executed on the 27th of January, and that could be found at EB 0205 to 0230. And it was duly registered. We have the certificate of the notary public, We have the statutory declaration. My lords, the story, no other word could come to my mind except concocted. The story concocted by the respondents about these documents is unbelievable. One of the first reasons why it's unbelievable. First of all, I think in their speaking note, my learned friend says, well, only in 2012, Mr. Niba was representing the children. He was only that is not true. In the cross-examination, Gina made it clear it was 2008. I will give you the reference in a moment. Ms. Jairam, by letter dated 21st of March, sent copies of the compromised documents to Mr. Niba. 21st of March 2012, EB 0253. My lords, the significance of this is that several months had passed and not a word from a learned friend, Mr. Niba, to say, Madam, my instructions are these documents are fraudulent. The children didn't have independent advice. So it puts a gaping hole in the story. Nothing, up to this day. The first time we knew that they were querying the validity of the compromised documents, it was not until the defense and counterclaim of the children were filed on the 20th of September 2013, some 1 year and 4 months after. My lord, is that the conduct of any attorney where there is fraud involved? You haven't told the other side that those documents are fraudulent? First time they raise it, 1 year and 4 months after.
Just remind us where we find that, please.
1 moment, please, my lord.
253.
353.
253.
253, sorry.
That's the letter.
Yes.
Yes.
And then it's
So we say,
the pleading that you just mentioned.
yes, 253. Right?
no, sorry, I thought you were referring to the letter.
No, not a letter, sorry. Quickly. Oh, I'll get it. 1 moment, please,
The
ma'am.
defence is at 273.
Huh?
273.
273. 273. The significance of the silence from a learned friend is that the inordinate delay impacts the viability, veracity, or credibility of these allegations they're now making for the first time. And it was only, my lords, it was only on the 19th of April 2013 that Lauralee Ramcharan brought proceedings after the matter had become contentious since the entry of the appearance to the warning. And you'll see the date, my lords, at 0074 to 0263. And significantly, my lords,
I was just wondering, one of the issues in relation to these agreements is whether what was signed was exactly the same as was presented.
yes.
And was there any evidence about that?
No, my lord.
Sorry, was there any evidence on behalf of the appellant that the documents that were signed were exactly the same as had been?
Yes, my lord.
And where do we find that?
And in any event, my lord, we are entitled to embrace the presumption what appears to be in order is presumed to be in order.
Well, I was just thinking in terms of how you would prove it. That you
I will
presumably call a person who was responsible for drafting the document, say that's the document that I sent in a letter beforehand to the individuals concerned, to the...
Well, my lord, the statutory declaration was accepted by the learned judge.
The statutory declaration... as
Made by Krishna D. Initial
I understood
D.
that to be as to the signatures rather than as to whether every single page was exactly the same as the...
Well, my lords, we say in the circumstances of the case, there was no evidence from them. Lauralee maintained that this was the document. It was duly registered, and they did not prove. I asked them, they took copies. I will come to those bits in a moment, please, my lord. And significantly, we had pleaded in the statement of case at paragraph 27 that this was not hostile litigation. In fact, my lords, what is the statement of case? Huh? Statement of case. EB. The very last exhibit of the statement of case was a draft. I believe the entire thing is in the reproduced record, not the electronic bundle. Find it for me, please, Sean. What is in the electronic bundle is simply the claim form that was sent to the children at that stage in November 2012, where they and Lauralee were claimants or proposed claimants. EB 256. EB 256. You will see that, my lord.
I was just thinking in terms, really the allegation of fraud includes an allegation against yourself.
Sorry, my lord?
Well, the allegation of fraud involves a document being signed that isn't, in fact, the right document.
Yes.
And that must, complicit in that, must be those people who are responsible for gathering the document together.
Yes. I did ask them in court, my lord. I'm glad my learned friends are here. I did ask them before the trial judge if they were accusing me of being complicit in any way, and they said no. I offered to take off my gown, my robe, and they said no. But try as we might, we can't find it in the record, because the first day transcript, it's not satisfactory, because like it didn't record everything. But I am saying it in front of your lordships, and that is my reluctance why I don't want to argue the case fully. I've asked my. But the point here, my lord, you see, Lauralee and the children was simply in this draft. Only Dr. Deonarine was the defendant, and that's the importance of it. And it had to be changed when they didn't sign at all. And my lord, the other point I wish to, well, we have covered that. It was in the matter of a number of things. And we also said in the matter of the Supreme Court of Judicature, the inherent jurisdiction of the Supreme Court of Judicature Act, and in the matter of the compromise documents. Okay.
I'm not quite sure what we're meant to get out of page 256 or 7. If you'd be kind enough just to summarise your submissions on that, I'd be grateful.
On what, my lord?
On page 257.
257.
I'm not quite sure what your submission is. It's the claim form.
Yes.
You took us to this a moment ago.
Yes. My position is that as far as Lauralee was concerned, as at this date, and even when the case before you was filed, she was not aware that there was any objection to the compromise documents, or that any allegation that was fraudulent, or the children had not been advised by independent legal advice. So this is, and this was filed, my lord, in the original proceedings since April 19, 2013. Before they filed it, of course, naturally, their defense, nobody had complained. Nobody had complained as at this time that the compromise documents were fraudulent. So, my lords, we say with respect, having regard to what has transpired, the reservations of the court below, those have been put to rest because of the order made by the Court of Appeal that probate be granted and so on. And therefore, there's no impediment in the way of dealing with the declarations. I know your lordships are reluctant to do that, but we will try to persuade you. Now, importantly, my lord.
You might want to address this, Mr. Jairam. You probably know that the board has a very settled practice not to interfere with concurrent findings of fact in the courts below. Now, in this case, there have been concurrent non-findings,
Yes. There are no concurrent findings, my Lord.
in the sense that both the courts of below have decided not to make final decisions
Yes.
about the factual matter in dispute.
Precisely.
Though the judge expressed certain quite firm views about it. Now, are you submitting that despite that, the board ought to make those findings of fact and decision now, or that they should be remitted to the judge?
Our first position.
First, with the second in the alternative.
Our first position, my Lord, and I'm sorry to press you, I'm saying based on the circumstances of this case, you are entitled to make those findings because there's no conflict. If there were conflicts or any conflict in the evidence, then I could understand the Lordship's reluctance. But there are no conflicts. It will be a colossal waste of time. The first point I wish to make about the cross-examination, my Lord.
To apologise, but I'm not totally familiar with all the evidence. And I certainly know that one of the daughters said that she signed a document, but she hadn't read it.
Yes.
Okay, therefore she can hardly give evidence that it was a different document that she signed.
Precisely, my Lord.
But I don't have a familiarity with all the responses of all the witnesses to the actual process of signing this document.
I shall make a mental note and come to that in a moment. May I? The cross-examination of Lauralee, the applicant, began at EB 1051, and my lords, at 1066, my learned friend who was cross-examining Lauralee, just below midway of that page, and he says, and that the agreement you are saying is between the deceased children, that is those he left the property to and yourself, right? She says yes, and basically what that agreement is about is what I'm sorry, how to distribute the deceased property, correct? And so on. So then, I'm giving you, your lordships, the reference. At page 1071, just about midway of the page, a lot of friend taking a swipe at me. You didn't go by a good lawyer. So, ma'am, I am putting it to you on my instruction. There was no agreement, whether it was lawful or not. There was no agreement between you and these children to abandon his will and to do what you want to do. Yes, answer, yes, correct. Question, correct? Answer, correct. Mr. Siunat, yes, correct. Judge says, I'm sorry, what? The answer, I'm sorry, can you repeat? That's the witness. Can you repeat the question? I think I don't understand it. Question, Mr. Siunat said, that's my fault. The judge said, senior, just repeat it, all right?
I'm sorry, which page are you on?
Sorry, my lord, 1071.
Thank you.
About midway down.
Yeah.
And when you go over, what my learned friend did was to withdraw the question. You said correct? No. Can you please, Mr. Siunat, no. Did you say correct? Answer, I don't remember what you just asked me. Mr. Siunat says, short memory, very short memory. Judge, well, I heard correct, but I think in fairness to the witness, you can just ask her over. Mr. Siunat, I am saying that these defendants, children of the deceased, are saying that there is and was never any agreement with you to abandon the will and to share the estate you want to. Correct? There is no agreement to abandon the will and, Mr. Siunat, well, and to advise, and to divide the estate as you saying, in this case, you divide it. Answer, I still don't follow you. Mr. Siunat, it's correct. You still don't understand? She said, no, I don't. And then he says, I will leave it there, ma'am. Answer, there's a problem with that question. Mr. Siunat, I will leave it there, ma'am. I withdraw the question. The judge said, you withdraw it? He says, I withdraw the question. And that was the end of his cross-examination next page. So he's never put, in accordance with Brown and Dunn, as we all know, the case of the respondents. That's the first thing that your lordships ought to take in mind, so there's no conflict. But it gets better. And when I was re-examining the witness, my lord, just for completeness, at electronic bundle 1078, you know, in a trial, you want to make sure you dot the I's and cross your T's. And I said towards the bottom of that page, 1078, Mr. Jairam, and I'm reading as it is there, my lords. I just want to be clear that the suggestions put forward by my learned friend towards the end, that was withdrawn. And the learned judge said, yes, it was withdrawn. And I have no further question. So the respondent's case was never put to the claimant. And if it was withdrawn. Yes. Now, in reliance upon the agreement, Lauralee paid a number of, sizable amounts of money to Mr. Farbstein, and those could be seen, my lord, at 0508 0509. Gina Sijatan, when she was cross-examined, my lords, it begins at 1166. And I will ask your lordships to please read 1208 to 1211. I'm being reminded of my time that I should allow Mr. Malone from.
Sorry, I've lost where you are. I had a note of 1166, 1166. Is that correct?
Yes, my lord.
What do you want us to look at on that page?
1208 to 1208 to 1212.
Sorry, who's asking the question?
I'm asking the questions. And you will see.
And who's the witness?
Gina.
Yes.
Then, my lord, you will see at skipping a few pages, of course, your lordships, I am sure, will read all of it. The next 1215.
What's the point that's being made here, Mr.
I asked the question towards the bottom of the page at 1215.
Yes.
Now, at what stage you, your brother, and your sister advised your attorney in Trinidad that the three of you and Laura had come to an agreement? And she says, what do you mean, what stage? After your father died? Right. You advised your attorneys here, no, Mr. Nibar, there are letters here that you and Laura had come to an agreement. Right. And a page over, my lord. So I'd ask those questions just at the top of the page. I don't propose to read them, my lord. At 1217, there are three lines in the middle.
I'm sorry, I'm simply not following the submissions you're making. You're giving us a series of references, and I don't understand at the moment what it is that you're inviting us to draw from them.
She admitted signing the documents, because at the top of 1216, I said, and in fact, there was an agreement signed, an agreement the four of you signed. Am I right? Yes, we signed an agreement.
Yes.
And that agreement only deals with U.S. property, etc. I was building up and then, my lord.
But did she admit signing
yes.
these documents?
Yes, yes.
Well, they presented to her and said, these are the documents you signed. Do you admit that?
She said she can't remember what she signed. And I picked it up as well at 1224.
Well, even the judge didn't know which document you were referring to at this point, looking down page 1216. Do we ever get it properly put in front of the witness?
My lord, yes, because I've skipped the reference because they were attached, and I was showing her the documents.
Well, if you're inviting us to draw a conclusion that based on the evidence, there is no answer to the case that you're putting, you're going to, with respect, as far as I'm concerned, have to be rather more precise about what it is that you're saying this evidence establishes.
It establishes that Gina and Terence have admitted that the signatures on the compromise documents are those of those two witnesses, those two parties. But, my lord, at 1225, coming closer to home, I said, no, Gina, you know that what this case is about, the enforceability of what we call the compromise documents, the agreement and the two deeds. You appreciate that? They are attached to Lauralee's with the statement. They are attached to Lauralee's case. Have you seen them, haven't you? And she says, the deeds, she was asking. No, the agreement and the 2 deeds. You have seen them, haven't you? She says, no. And I ask, you haven't seen them? I don't know what a deed looks like. And
sorry, what page are you reading from, sorry?
1225.
1225, yes, thank you.
And there was an interruption, small interruption by the court at 1225. The next question immediately, now you have accepted, Gina, that this is your signature on the document. Am I right? That's my signature, but inaudible. That was before I read it. You never read it? No. Okay, but you chose not to read it. No, I never saw it. You never saw it? And she says, no, didn't you ask what you were signing? Didn't you inquire about what it is that I'm signing? Yes, but I was presented with this paper that I signed. I was presented with this one, and I asked, you were presented with a paper and what? Yeah, I wasn't presented with a packet like that. There's a lot of papers here. I didn't. I just skimmed through the first couple of them, and I don't remember those papers. And where are your copies? Did you take copies? No. Did you ask for copies? No. No, that's one, the agreement. And if you look, you see the agreement is dated 27th of January 2012, and you could take it from me that you may not know, but it is registered in the deed registry in Trinidad and Tobago. Okay, let's look at the deed now. It's 49. You see the deed? You see your signature there? Yes, I see my signature there. Signature. And do you accept that as your signature? Yes, that's my signature. Now, did you take a copy? No, like I said before, I never saw those papers. I did sign the paper. And the court says, answer the question, please. Did you take a copy? No, thank you. Did you ask for a copy? No, I didn't know I could. Now you see the document I showed a moment ago, and this is both dated 29th of January, and she says, this one says 27. I said, sorry, 27th. Now let's go to the third deed, LRO 50. You see that? Yes. Did you sign? Did you see your signature on that? Yes. And what is the date of that document? 7th of June. What year? 2012. Right. Yeah. And she said, yes. Now I have to ask you the same question. Do you have a copy? No. Did you ask for a copy? And she said, no. And my Lord, you will see on the next page, 1228, I ask, maybe I should read it. Now, in the agreed bundle, my lady, tab 8, do you accept that by May 21st, 2012, your attorney, my friend Mr. Nibar, had received copies of the agreement and the first deed? Now, this last one here, do you accept? I don't know. Question, well, it's a matter of record. He is your attorney now, isn't he? Yes. And he receives, and were you in touch with him? Yes. What, answer, what days? Question, 2012, May 2012? I don't know. When did you first retain him? After my dad died, 2008. That's the point. And I said, 8, good, meaning 2008. And I had put to her the next question, my Lord. That's a mistake, 20th of September 2003. I put to her the defense and counterclaim they filed on the 20th of September 2013. And it was the first time they raised it. And then, my lords, at 12:29, she said she felt she was being forced. But then she goes on to say, in the next, I will ask her lordship to read those pages, 12:29, 12 to 12:34. She said she did not sign in the presence of the witness. At the top of 12:31, she says, sorry, I was asking her, their case, my lord, sorry, was that the appellant was their babysitter, contrary to what the appellant had alleged. And she said she felt at the top of page 1220, she felt like she was being manipulated. And I asked her, who manipulated you? She says, Laura. Laura is the appellant. Answer, how old were you? She says, when I signed these documents, yes, I said. That was 2012. How old were you? She says, 24. So you allowed your babysitter or your ex-babysitter to manipulate you? I suppose I was being facetious. And she said, yes. You said she was your babysitter? Yes. I am suggesting to you that is not true, Gina. And you signed in the presence of a witness, didn't you? You all signed in the presence of a witness. And she says, not that I can remember. But you can't doubt that because, and she says, it was us here. It was me, my sister, and my brother here. Where did you all sign? At my brother's store. And I said, where? Next page. At the stores because she gave it to me in an envelope. She would give it to me in an envelope and she'd tell me, take it to my brother's store and I would sign and we would sign it there. So you had an opportunity to take a copy. You had an opportunity to take a copy of what you were signing. And she says, right. And was it the fact that the first set of documents you signed, it was not signed properly and it had been done over? She doesn't accept that. Point is, my lord, if she's to be believed, Lauralee was not present when they signed. It shows you they were changing their story as they went along, inventing. And then I put to her squarely, just on the midway of that page, 1231, do you accept that Laura worked very hard for your dad throughout his lifetime and even after? And she said, taking care of us, yes. And I said, in the business, yes, she worked in the business. And my next question, would you grudgingly say she didn't contribute to the acquisition to at least inaudible Trinidad property? She says, I don't know. I am suggesting to you that the defense that you have all put is not genuine defense. Someone or some person or person have put you all up to it. It is not Gina and Lisa. Someone has put you all up to it. Isn't that so? And my lords, I'll ask you to read the remainder of that. The last bit I want on the transcript is Terence. I will be content to give the lordships the references. His cross-examination starts at 1236.
Sorry.
1236.
Thank you.
My first question about the power of attorney that his sister Laura gave to him.
Well, it may be, Mr. Jarham, it's a matter for you, but it may be that if you give us the references, we can look at this. You know that the time that's been allowed for the submissions on behalf of the appellant expires at 10 minutes to 1.
Yes, I'm getting there. He accepts the power of attorney, and I ask him, my lord, I will ask you to read, please, 1242 to 1259. He was 39 years old when he signed the compromise documents, and he was 43 at the trial. And he told the court that he went to college, not only high school, but he went to college. And the other references, my lord, are 1260, I gave you that, the lower half, 1261, the lower half, 1262, the upper half, 1282, 1302 to midway of 1309. And I want to say, and my lords, at page 1307 to 1309. Their case was that this lady was married to Terence. In fact, she was. But I had put that they were not husband and wife in the true sense. It was a marriage of convenience. And he was maintaining that she was married to him. So when Peter died, there was a funeral program, and you will see that at 1207. And printed on that program, it had Peter was the father of the named children, and he had seen it before and approved of it. And I asked him, what does it say? The wife of whom? And at page 1308, I asked him towards the bottom, what is written there? He says, Lauralee. Father of whom? So he was hoisted in this petard, this tissue of lies that they were telling on this lady. My Lord, I will. There are a few points I would like to make on my learned friend's written case and the speaking note that they have, but given my constraints of time, I will see whether we have time in our reply. I will hand over, with your Lordship's leave, to my learned friend, who will continue the argument.
Thank you, Mr. Judge.
I am much obliged.
Mr. Pennington-Benton.
Thank you, my Lords. It wasn't quite how I thought things were going to go, so I don't have as much time as I thought I would have in order to deal with all of the issues, although I think actually, certainly on the main issue, we have now canvassed most of the ground that we need to canvass. I wonder, though, whether I could just return to one or two of the questions that were put and clarify one or two points. And then just turn to the statement of case and the judgments of the two courts below to explain why we respectfully say that the courts were wrong not to decide this issue. And then I'll deal at the end with the question of relief, but you can see where we are hoping to go with that. The alternative, of course, being that the matter simply be remitted.
Remitted to the same judge?
Well, my Lords...
Sitting as a High Court judge?
Well, my Lords, the difficulty, of course, is this happened, the trial happened some 6 years ago.
Yeah.
So the proposal, I think, would be to have it remitted to the High Court to be heard by the same judge if reasonably practicable.
Yeah.
If not, a fresh judge. Because, of course...
same pleading, same evidence.
Yes. Same pleadings, we say, same evidence, but those would also probably be matters we'd have to have an argument about below. But ideally, we would be saying, so there's no procedural advantage, effectively, accorded the respondents due to the error of the courts below, that the matter should be reheard, if it has to be before a new judge, as it were. It should be heard on the same pleadings and really the same evidence, because what we want to avoid here, apart from the additional cost of having to, serve another claim in America, replead the thing, call the evidence and so on and so forth, is to allow, effectively, a party to have a dry run at it.
When you say the same evidence, do you mean just the witness statements?
Yes.
Or do you mean the record of the cross-examination?
Well, the same witness statements, and then the transcript would be admitted into evidence, and you could cross-examine on it. But what you can't do is say to a new judge, "Well, have a look at the transcript and decide the matter." I accept there's authority that says you basically can't do that, because you have
There would have to be a fresh cross-examination.
to be fresh cross-examination.
Was all the evidence in chief given in witness statements in this case?
Yes.
So what does the transcript add?
Well, it just shows the answers that they gave previously. So obviously, if they give different answers, then
I see.
So you put the transcript before them.
Potentially as having previous inconsistencies.
A bit like an insolvency practitioner's interview. You put it to the witness and say, right, well, there you go. Well, this is what you said all those years ago. Now you're changing your story.
Right.
That sort of thing.
But your primary submission is that we're in a position to resolve these factual issues
Yes.
on the basis of the transcripts that we have
Well,
now.
That is the primary submission, but the way that we put that primary submission, and I think we are compelled to put it in this way, is to say that because of what was pleaded, which was effectively trickery, we signed something, but you've swapped the pages around.
Yes.
Because of the seriousness of that allegation, to prove it on the balance of probabilities was always going to be an uphill struggle. You would need particularly clear and cogent evidence. On the basis from them, yes, from the other side, taking the witness statements at their highest, they amount to a bare assertion by two of the legatees' children, not the other two, because the other two didn't turn up to trial. They amount to a bare assertion by Gina and Terence that these pages were swapped around. As my learned senior has explained, even that bare assertion wasn't actually put to the appellant. And therefore you're in Brown and Dunn territory. She says in clear terms, I was there, this was the agreement, you signed it, clear as day. If nobody's put it to her and given her the opportunity to say, well, of course I didn't swap the pages around, then it's not open, actually, to the trial judge to disbelieve the evidence on oath.
Gina can hardly say the pages were changed around because she didn't know what pages there were.
So her evidence, at taken at its highest, doesn't even actually amount to that bare assertion. Terence's evidence is slightly different, and the page reference for that is 456. There you'll see there's two paragraphs effectively at page 456. I know my Lord Stevens asked a question about the gravamen of his evidence, and that's where you'll find it. Sorry, it's actually, I think my page is right. No, I am right, sorry, 456, paragraphs 17 and 18. And of course, my lords, it goes beyond, I mean, I understand my Lord Stevens' point, well, hang on a second, they accept signing something, but the allegation is actually that you're swapping the pages around. And of course, Krishna Hari says he witnessed the signatures, but that doesn't necessarily mean somebody didn't come along later and swap the pages around. But the difficulty is their pleaded case and their evidence is also that they don't know who this guy is. Their case is that they don't know who Krishna Hari is. They never signed anything in front of him. So therefore their case, although they say we signed something, it's actually saying we didn't sign this at all. Not this document we didn't sign. Well, that can't be right. Because it's got their signatures on it. I mean, we can see they're the same in all three documents, and they're not saying they're not their signatures. But if they're saying the person who said they witnessed these signatures, that's all made up, the allegation becomes even harder to prove, because, of course, Krishna Hari gave a statutory declaration to a notary public in the States. And, of course, that's why the judge says, well, that just blows the case of fraud out of the water. So really the submission before your lordships, and I don't, in the short time I've got available, want to spend too much more time on it unless I have to. The basic submission is, this judge didn't decide the point. She should have done. Had she decided it, there's no way they were winning. And you can see that by the...
So there's no
way they were going to win the point. And you can see that by the judge's preliminary indication in her judgment. And in fact, even taking their evidence at its highest, we respectfully submit that there is no rational basis upon which actually the judge could have found in their favour. And therefore, in those circumstances, it's not so much asking the board to determine a free-floating finding of fact, but to find, if your lordship wanted an analogy by reference to a reverse summary judgment application, that this case of fraud just couldn't succeed.
Sorry, I missed that.
This case on fraud just couldn't succeed.
Thank you.
It's effectively saying, this is the reverse summary judgment application, but you have the added advantage of seeing what the witnesses are actually saying in their witness statements and saying in cross-examination. You say, look, no judge, properly directing herself as to the issue, could actually decide this in favour of the respondent. And therefore, yes, that leaves me with the more prosaic point as to why we say the judge and the Court of Appeal were wrong. I don't have very long to deal with it, but if I could just ask your lordships to turn up the High Court judgment, please, in the record. Just bear with me a second, please. Right, so paragraph 66, please. That is at page 25 of the electronic bundle. And I understand, of course, my Lord Borough's point about, well, you can vary a testamentary deed, a will, by agreement between the legatees. I think that the difficulty here was whether Jonathan Sumption in that case was saying that you can vary the obligations of an executor, or whether you can vary the actual document itself. And what the judge is saying is, well, this is not a Saunders and Vautier, this is not an ordinary trust document where the beneficiaries can call in the trust property and vary the trust deed itself, which of course absolutely entitled beneficiaries can. What the judge is here saying is, well, I'm not sure in the case of a testamentary disposition, in the case of a will, it quite works like that, because the will is what the will is. You can vary the executor's obligations by entering into an agreement between the legatees, and the executor will be bound by that agreement in his or her execution of the will, but that's not the same as actually varying the will, and that's why you can't replace the executor with somebody else. None of this matters, because we're not appealing any of that stuff. Those are the Court of Appeal held probate reliefs anyway, and it says we should have issued under Part 72 rather than another part. None of that makes any difference to us anymore, because our simple point is that irrespective of whether those are probate reliefs, in fact the High Court decided them and rejected them because, in fact, decided that we can't appoint a different executor, decided that we can't stop the will being admitted to probate. And in any event, the real thing that needed to be decided was the application for a declaration in paragraph 2 of the claim form and paragraph 5, and an order in paragraph 4. If your Lordship's reference, it's page 76 of the electronic bundle for the claim form. I'm sorry, it appears in a couple of places. This is the reference that I've prepared to use. I'm told it's the same. So page 76 of the electronic bundle. A declaration, this is paragraph 2, that the said agreement, the said deed, and the said deed of rectification are all the same, compromised documents, well, almost the same, sorry, signed by each of the beneficiaries, ... showed on their face an intention to create a compromise having immediate legal effect. That's borrowing words insofar as it matters from the judgment in Crowden and Aldridge. Intention to create a compromise having immediate legal effect, directing the court, or you can ignore that for a moment, directing ... the executor, the defendant, Dr. Ramraj Deonarine, to vary ... his obligations in the administration and distribution of the estate. So in other words, they're saying, all right, if Crowden and Aldridge doesn't stand for the proposition that the will itself can be varied, it certainly stands for the proposition that the executive's obligations can be varied, and therefore we want a declaration that that is what this has happened here. And then over the road on page 77, at the top, paragraph 4, an order that the estate of the deceased be distributed in accordance with the compromised documents. So, of course, that follows like night follows day, we say, because first of all, you get a declaration that the documents are good to go, and then you have an order that the executor, notwithstanding the terms of the will, must distribute in accordance with the compromised documents. So in those circumstances, going back very briefly to the High Court judgment, the judge rejects the claim to oust Dr. Deonarine. Fine. She says, look, forget that. The will is what the will is. It should be admitted to probate. She says at paragraph 82, withdraw the caveats, let the thing go to probate. It then says, paragraph 77, page 27 of the electronic bundle, in my view, there is no reason why the claimant cannot seek to enforce the compromise documents following the application and grant of probate. This is my Lord Briggs' point about timing, or it may have been Lord Burrows, sorry. But just pausing there, what does the judge mean by the word enforce? Well, in circumstances where she's rejected the idea that the executor be displaced and rejected the idea that the will not be admitted to probate, all she can mean there is the declaration that we seek at paragraph 2 and the order that we seek at paragraph 4. There's nothing else that enforce can actually mean. Why, we respectfully say, gives no reasons as to why she says that it should wait. She goes on to paragraph 79 to consider the counterclaim, which is, of course, there's a counterclaim by the respondents for a declaration that the compromise documents are invalid because of a fraud. And then she says over the road on paragraph 81, having regard to my ruling on the merit of the claim, well, the claim includes a claim for declaratory relief, it will be open to the co-defendants, now the respondents, to launch a full attack on the compromise documents should the claimant seek to enforce them following the grant of probate. With respect, that just makes no sense.
So that's where, in your submission, she goes wrong.
Yes.
Is that right?
Yes, because we say there's no rational basis for making everybody wait. In other words, the co-defendants have already launched a full attack on the compromise documents. Evidence was filed, pleadings were filed, people were cross-examined on those statements. There was a whacking great big trial over the issue, hundreds of pages of submissions filed with the judge saying who should win on the compromise documents, whether they're valid, who's pleading fraud, who should prove, and so on and so forth. And the judge says, well, don't worry about all that, just do it all again later. And we say they just, with respect, cannot be, and in any event the judge doesn't provide one, and I'm hoping that 4 law lords aren't about to tell me that there's a brilliant reason, actually, that the judge must have had in mind, but respectfully, we just cannot think sensibly why it would make sense at
There's
this
no
stage.
procedural reason why it had to happen, because, as I understand it, you would adopt the observations that have fallen from my lords to the effect that there's this issue of, so far as it's a live one, could be decided by the judge, whatever the nature of the proceedings before her.
Yes, but even worse than that, even if you accept, the Court of Appeal found in terms that this was an ordinary general civil claim. So even if you accept that we were naughty and we tried to seek relief in that general civil claim, that we should have sought in probate proceedings, i.e. under a different CPR, this particular relief was undoubtedly a general civil relief. So even if they were right about all the other things, so in actual fact what happened in this case is the courts decided the probate relief, even though they said we shouldn't have brought it in a general claim. They decided the probate relief and didn't decide the only relief which on their own judgments was in fact a general civil relief. On
the basis that it could more appropriately be decided in the context of contested probate proceedings?
Well, no, well, it's worse than that, because the judge says, forget the caveats, withdraw the caveats, because on my reading of Crowden and Aldrich, your argument about varying the will is wrong.
I see.
So not only does the judge shut down this claim, she shuts down the probate claim too, because of course once there's a grant of probate, that's it.
Can I just understand one aspect of the matter? Dr. Deonarine had never actually applied for a grant of probate, had he?
Yes.
Oh, had he?
Yes,
there was a caveat against him doing so,
He
and a
made that
warning to
application.
the caveat, which suggested he wanted to apply for a grant.
I think
And you entered an appearance to the warning. Did he ever?
Yes.
As I understand it, probate still hasn't been granted even now.
So at 108 there's the application for probate. That's on the 15th of May, 2009. That appends the will as well for your records, and an inventory at 113, and then the caveats follow that. They're renewed.
So the caveats follow the application for probate?
Yes. And of course, Dr. Deonarine filed a defence in this claim in respect of the compromise documents, largely neutral.
Yes.
However, when it came to the submissions before the court and the Court of Appeal, he dumped himself in their camp because there were one set of submissions filed on behalf of the respondents, both in the High Court and the Court of Appeal, right?
Yeah.
So, of course, by that point, Dr. Deonarine is saying, because he's aligning himself with their submissions, I don't buy these compromise documents either. So, of course, this is the problem. This is why we were filing caveats. This is why we were doing all these things, because once the will gets admitted to probate and Dr. Deonarine gets his hands on the estate, his position is, I'm distributing in accordance with the terms of the will. And therefore, the estate is gone before we've got a chance to actually say, well, hang on a second, there's this agreement. So not only is this a case where it was questionable, I'm not trying to appeal a case management decision to the board, because I think actually, somebody could have decided it differently. It was absolutely imperative in this case that you decide the question of the validity of the compromise documents before the will gets admitted to probate. And not sidestepping. I don't have time, unfortunately, my lords, to take your lordships to the Court of Appeal judgment, but I'm afraid I can only really ask your lordships to read paragraphs 8, 16, and at the bottom of paragraph 16, the Court of Appeal acknowledges the concession by the appellant by the Court of Appeal hearing, but there's not challenged the judge's determination that the caveats preventing the grant of probate be removed. So in other words, by the time we get to the Court of Appeal, we're saying forget it. Let the probate go ahead, let the will be admitted to probate, and ergo Dr. Deonarine must be appointed.
But decide the compromise. Yeah.
And the Court of Appeal basically says, well, the judge didn't do it, and she thought it was more appropriate for the matter to go back to. Yes, I do need to do a bit. Slightly concerned about the time. And then what the Court of Appeal does.
Well, the paragraph 59, it seems to be the last sentence of that paragraph. It seems to be a case management decision of some sort or other, made at the end of a case rather than the beginning of a case.
Yes, and we say, of course,
parties.
ordinarily I wouldn't stand before your Lordship's board and argue about whether or not a judge at first instance is right to make a case management decision, but this was a decision to shut down a central part of somebody's claim. And we say, actually, no reason. All the Court of Appeal says, in her opinion, it was more appropriate to bring such an action after probate had been granted. Why? Why was it more appropriate to make the parties start all over again?
Presumably, the only reason she puts forward is in the next sentence, and that is until after the estate of the deceased had been formally vested in the putative executor.
That's just not a reason, in my respect.
Yeah.
There could be no rational.
The putative executor might have had some. He wasn't a party to these agreements, so he can't say factually whether they did or didn't occur, and or whether there was undue influence or whether there wasn't. But the only issue would be as to whether or not he wanted to raise a legal issue, and there is no legal issue here.
And that's why I say it's important that Dr. Deonarine put himself into their camp. So in other words, we know what his position is.
And the clearest, just give me, if you'd be so kind, the clearest reference to that again, the basis for your submission that he put himself into, as you put it.
It's simply reflected in the fact that by the time we got to the hearing, the written submissions were filed by one lawyer on behalf of all of the defendants, yes, including Dr. Deonarine, and the written submissions have been handed up in a separate. It's about as far as I can get, I think, in the time. My only other concern, of course, is there is the point on the Siparia land. otherwise known as Laura's Valley, although we tried to put it in more neutral terms in the statement of facts and issues. This is the judge effectively saying, well, look, although I've not ruled on the compromise documents, I do nonetheless say that that a common intention trust, a constructive trust arose, Jones and Kernot, Stack and Dowden type trust arose on the facts in favour of the appellant in respect of one area of land. And what the Court of Appeal says is, well, that's all very interesting, but that wasn't pleaded, and therefore the judge wasn't entitled to decide it. Now, in our case, we have said that the Court of Appeal was wrong to take that pleading point because it wasn't taken by the respondents in the Court of Appeal. We are wrong about that because some further documents came to light, and it turns out, in fact, that the respondents did take the point of the Court of Appeal. It wasn't in their notice of appeal as far as I could locate it, but it certainly was in a set of reply submissions that we hadn't seen, or I hadn't seen, or somebody hadn't seen. So it was taken in the Court of Appeal eventually, and therefore it was a live issue. However, we say that the Court of Appeal was simply wrong. My Lords, I think I would probably need more than 2 minutes.
When you say if we read the pleadings, you'll find it was pleaded.
Well, I do say so, and the difference between the High Court and the Court of Appeal, effectively, although there's no reasoned decision by the High Court, but she must have made a decision on this, is the Court of Appeal says that paragraphs 1 to 7 of the particulars of claim were background, the whole stuff about beneficiaries and so on. But note in paragraph 4 of the statement of cases is at page 92, the claimant refers to herself as a beneficial owner of these properties. So right from the beginning, she is in fact claiming to be a beneficial owner. But of course, when this pleading was filed, as your lordships have heard, the appellant's lawyers didn't think that this would be a contentious set of proceedings. So in other words, they thought they were basically getting the court's rubber stamp. We'd get a declaration almost by consent, and then we'd pass that to Dr. Deonarine and say, well, there you are, that covers you. Please distribute the estate in accordance with the settlement agreement. So it wasn't put, so we accept, if your lordships turn to the relief that's claimed, which is at page 101, of the electronic bundle, we don't plead, oh, in the alternative, there's a trust. What we do plead over on page 102 is all consequential orders at paragraph 13 and further and or other relief as the court shall deem just.
There was never an isolation of those, I'm going to call it Laura's Valley, just for the sake of shorthand. There was no specific confinement in anything that you've said to that particular property, was there? Other than, as I understood it, under a donatio multis causa argument.
Correct.
So it's hard to see how the other side can really see what you were arguing about a trust confined to that property.
Yes, I think what the judge says is, I understand, looking at the evidence of the nature of the relationship, the working for the business in Miami, sending money back, I can see that you made out your case on trust, but not the type of trust that you were arguing, but a different type of trust, i.e., basically a Jones.
None of that would go to one particular property, would it?
Well, what the judge says is you've only made it out on the evidence in respect of one of the properties. I'm not satisfied that on the evidence that actually there was a common intention between you with respect to all the other properties, because this particular property, hence its name, was a special property specifically for her. That was their place, basically, in Trinidad. That's the way the judge, I think, must be taken to have reasoned it. Therefore, you don't get home on the evidence in respect of the other properties, but you do get home on the superior lands.
Can your alternative case lie side by side with the continued pursuit of the compromise agreement?
Yes, well, this is what the Court of Appeal found. What the Court of Appeal basically said is, by reference to a first instance judgment of Mr. Justice Neuberger, well, the judge could have granted you permission, could have granted you the relief under the further or other relief provision, and both parties were filing submissions on Jones and Kernot and all that sort of stuff, so it's not like this was a surprise point. The point taken by the Court of Appeal was my Lord's point, to which we were saying, well, of course you can, because our position was that these properties were held on trust because of the nature of the relationship and the contribution towards their purchase and upkeep and all the rest of it. But we recognised, or the appellant recognised, that there may be a dispute about that, and therefore we entered into the compromise documents, under which, in fact, she gets some extra properties and things are swizzled around and all the rest of it. And there's nothing inconsistent, certainly not on the facts, between those two positions. We say, well,
if the compromise falls away,
then we'll go back to a
then you say that the original claim.
We go back to our common law rights. And that's the only reason, or equitable right, that's the only reason the Court of Appeal gave for saying that the judge just went wildly wrong in deciding this case. Didn't say all the other side were taken by surprise, it was all terrible, blah, blah, blah. Just relied on this one point, which is my Lord Briggs' question. And we say the Court of Appeal is just plain wrong about that. Of course it's consistent, it's entirely consistent.
Make absolutely certain about what you want to have remitted to the trial judge.
Sorry,
and that is the present pleadings. So if the trial judge finds this hasn't been pleaded properly, then you can't make it as a fallback position.
Sorry, my Lord, I have to be honest.
You want the matter remitted on the present pleadings without anybody having an opportunity to mend their hands. That applies to you as well as to anybody else. So one leaves it up to the trial judge, the High Court, to decide whether or not it has or has not been properly pleaded. If it hasn't been properly pleaded, that's a case, an alternative case, that is no longer available to you.
I think I would I understand the question. I suppose the answer is we think our position will be that the things should be pleaded on the same pleadings in respect of everything, but obviously it's not going to prevent either side from making an application, I suppose. But and it would be unusual, I suppose, for the board to direct at this level that the courts below are prohibited from allowing amendments to the pleadings. But it would be, I mean, if we can go that far, I think we'd. I better take some instructions before I just ad-lib, because that's a deadly question, as I'm sure my Lord knows. But can I just take some instructions on that? Rather than time filling. Yes, I think I'm just being asked to make the general point, which won't be lost on your Lordship's board, of course, that actually, whilst we are asking the board to do something quite unusual by rejecting the fraud claim or potentially remitting the matter back, of course, we do have in mind the board's concern about frequent appeals here as of right, dealing with questions of concurrent findings of fact and procedural wranglings and case management decisions and so on and so forth. But of course, this is a classic example of one party throwing in a procedural argument to knock something off. Sometimes a judge takes an interest in that point, and form succeeds over substance, as it were. And of course, the difficulty here is if somebody at some point doesn't stop that cycle, then you just have the same claim coming back up the tube again to the board. So actually,
well, Mr. Pennington mentioned you may want to take instructions in relation to the point on which you've just been addressing this. We'll hear you briefly at 2 o'clock in relation to that if you have anything further to say in relation to that. But I think that probably concludes your submissions for now.
It does indeed. Thank you very much.
Thank you very much. We're grateful. Mr. Soitler. sign that.
My Lord.
Are we continuing?
Yes. We have a few minutes that we should use
All right.
just before we.
Before a break for lunch?
Yes.
Okay, I was just wondering. Yes. I think the question that was posed by learned President at the beginning was whether the Court of Appeal was correct in saying that, and of course the High Court, that the issue of the validity of the agreement, compromise agreement, should await the grant of probate. Am I correct, my lords?
Yes.
Yes. And we are saying for several reasons that was the proper approach. Now, when this case was pleaded, we found that there was considerable confusion as to whether it was probate proceedings or just a straight civil matter. And I think that the court did, when I say the Court of Appeal did appreciate that there was that sort of confusion as well. When you look at the way this case was intituled, my lords, it's not a straight civil case that you are asking specific reliefs in cause of action then. If one were going to the court to say, well, look, I want the court to determine the validity of this agreement, it would have been a few lines saying, we are claiming a declaration that these documents comprising this agreement were made between the parties and therefore enforceable. But when the appellant in her claim before the High Court set out all the probate laws, wills and probate, and all the other documents, it was something which...
Mr. Sunath, I understand that there were some confusing claims brought.
Yes.
But I also understand that this claim in relation to the compromise agreements was pleaded.
It was, my lord.
And evidence was called about it, and that your clients had as much opportunity as they liked to call whatever evidence they wished in relation to it, and that there was a full trial in relation to that issue.
That is correct. And it is because it was pleaded that we had to respond to it, and we did out of deference to the other side. You pleaded a case and you put evidence in. So for completeness, we did that.
Why wasn't it decided then?
It was not decided.
Why wasn't it decided?
And it was not decided because we had raised in our submissions that basically it was contentious probate proceedings that had been brought. And this was not the case that really was brought by the claimant before the court. And because we had the application for probate, we had the caveats that were filed, we had the warning and the answer. All those things are done in relation to contentious probate proceedings. So our answer to that was, you pleaded a case as though you are challenging the will itself. And neither in your pleadings nor in your evidence did you raise anything to set aside the will. Although you had raised...
Sorry, just to get the groundwork absolutely clear. You accept that the beneficiaries under this will can give directions to the executor to distribute the estate as they wish.
We have a bit of difficulty with that, Malaj, as you would have seen from our submissions. And we feel that it goes against the making of wills. If you make a will and the testator in that will is giving instructions, directions as to what he wants to be done with his estate, I do not think it was disputed that a will is a very special document. It is sacrosanct in the sense that he is saying, this is my property, this is what I want done with my property. I think what the confusion is there between a trustee under a will, that is an executor or an administrator being treated as a trustee, and a trustee under a trust deed. They are not the same.
Do you not accept that deeds of variation to wills happen day in, day out, and are always regarded as valid?
Well, it is in that context we are saying that since the testator has determined what he wants to do with his property, to vary that would be rewriting the will.
All right.
Can I just
Well,
ask you, give you advance notice of a question I'd like an answer to after the short adjournment? I understand that Dr. Deonarine has not, in fact, still not obtained probate.
No, well,
Since the abandonment of any attempt to stop him to do so was made in the Court of Appeal. My question now, I don't answer it now, but I don't want you to tell me at 2 o'clock you have to go and get instructions, if you can get them over the short adjournment, is why not?
my Lord refers
I'm
to
not
the...
asking for an answer now.
Yes.
Right. We'll pursue that at 2 o'clock, Mr. Signer. Thank you very much. We'll pursue that at 2 o'clock.
Very well, my Lord.